Well, Henshaw here again, your friendly local constitutional coop out here in California. And more exciting news for you coming off of a trip and a visit to my friend in Southern California. And I'm going to hook back up with him as soon as possible, Adam. Um, but what we want to talk about today are some major big issues that are going on here today. And if you know what to do about it, you can take things into your own hands in the trial court and stop them and be done with it because the issues we have, the magnitude of them, is so great that it sets an unopposed record in the trial court of multiple acts of treason, while at the same time either getting the case dismissed by that purportedly neutral magistrate, and or getting you out from under in any event. And you should be able to do that because there's no trial by jury anywhere in sight here. And that was one of the foundational uh, basics what was created in 1787 to 1791 with the U.S. Constitution, but it's nowhere in sight today. Once we get it back, the ball game is over. These corporate entities are out of business. See you later. And we can start to invoke our rights secured by the Constitution. This is particularly true with mortgage banksters, for example, or subordinate corporate landlords that want to come on and try to evict you out of what they think is their property. And the common denominators here are quite a few because, we have rights. And when you buy real estate, for example, and you want to get a land patent on it, we'll be doing a separate video on that as well. But when you do that, you have property rights. Right now, using fictions of law across the board, but the 14th Amendment, they assume all you have is an equitable interest in your property. Because the Supreme Court ruled in the case of Vinny's case a long time ago, Bank of Columbia v. Oakley, 4 Wheaton 235, 1816, I think. When you use these, notes, and even back in the day, and you borrow from the bank, that you made a voluntary, knowing, and intelligent waiver of rights for all apparent and intended purposes, and you use their notes and you forfeited, among other things, your right to trial by jury according to the common law. We haven't done it. You haven't done it because of the failure of the lender, quote unquote, to make a full disclosure of all the terms and conditions of the agreement when you signed it. One of them was particularly for real estate purchases. All the bank does is loan you out at best Federal Reserve notes, otherwise known as paper money, and there's nothing behind them at all. So when you use Federal Reserve notes, you become a hypothecator of goods or stipulator in the admiralty, and you have no enforceable rights. But that's the way it is, if you voluntarily do something like that. But we haven't done it, and they can't make us pay for it because when we use these Federal Reserve notes, in our case, represent our property in the form of our time and labor. It's not recognized in any department of the de facto National Socialist government, and it needs to be because that's where our property rights are. But they think, and you'll learn with the non-existent 14th War Amendment, they think not only that you're a subordinate corporate entity, but you're a dead one that has no rights. And one of the things we'll be doing with some of my paperwork in my constitutional defense document packet is saying, okay, if they're going to make the claim for jurisdiction and venue that has vested here, you have to prove, number one, that the 14th Amendment exists, and number two, that we're dead entities. And to that end, we want you to produce a certified copy of our death certificate. They can't do it, can they? We're not dead, and you would think as soon as we walk into the courtroom, a stupid-ass black-old bastard could tell on a moment's notice, we're not IBM, Chase Bank, Microsoft. We're not corporate entities here. for real people who have creator endowed inalienable rights that they have to deal with. And really, what should happen with that, what the Supreme Court says, has to be a neutral magistrate sitting up there in a black robe, and that's Toomey v. Ohio, 273 U.S. 510. Once he takes about 2 seconds to figure out that we're not dead, what he does is dismisses the case with prejudice to the cause, sua sponte, on his own motion. See you later. Have a nice day. How hard is this? And yet today it never happens because of all the corruption in the government that we have. Most of it centered in the State Bar Association and the American Bar Association. And in my documents, by the way, you're going to get some documents hot off the presses here. They're going to rip them a new one because we're saying in no uncertain terms, if all they listen to are goddamn attorneys here and or pros, they litigants with specious, frivolous, sovereign citizen arguments, you have to go in there and present all of our unopposed structural jurisdictional errors on the record. Has to be that way. If it isn't, there's no right to trial by jury according to the course of the common law. There's no judicial courts. Apparently, for all intents and purposes, courtesy of the ratification of the non-existent 14th War Amendment, there are no sovereign independent states remaining which were admitted into this union. And that's the difference between the federated Republican form of government and today's elected despotism. 3 wolves, 2 sheep, voting on what's for dinner. To learn a lot more, send me an email, youwinnincourt@gmail.com, and you're going to get a life load of lessons there. A lot of it you instinctively understand, but I have the ability to connect a lot of dots. It's a God-given gift for which I'm thankful every day. Just as I am with my excellent health, that too, here I am, almost 76, and my great health maintains me and keeps me going here. I think I was put here to do a reason, and I'm going to be here until that either gets done or it's well within sight of getting done. That's what they can't beat, that kind of passion. They have no answer for that. A jury that we're never going to see is going to recognize that inside of about 2 minutes. They'll figure out who the hell knows the law and who doesn't, and who cares about the nation and republic and who doesn't. That's leverage. What that means is we're going to set an unopposed record in the trial court and get the bastards to get off your backs, pay us off, make us go away. That's a really good result. For the time being, that'll work. I think with the start of the next term in the U.S. Supreme Court, we may start to do a lot better here now. If Trump wins the quote-unquote election, and now Thomas and Alito can retire and get 2 more young gunslingers in there on the court, and they'll have that majority for the next 12 to 15 years. So that's the exciting part, and they know it on the Supreme Court, and they know what they've done too in the past. They've been complicit here. They know for the last 90 years. But the good news now is they're in the 4th term of an all-out assault on the administrative state. And when you read some of the opinions that I'll be sending you with, getting my materials there, it's a done deal. You're going to recognize immediately what happened to you, even if it seems to be in a different context. These justices get it now. And we have the ability to get out from under for the first time in quite a long time, like 90 years, maybe more than that, and get our nation and republic back. And if that happens, I'll be the happiest person on the face of the earth. That's what I'm put here to do. So that said, send me an email, youwinnincourt@gmail.com. Subscribe, like the video, tell your friends, get the word out. The sooner we take action, the quicker we get these bastards off our backs. Thank you.